Well, I just would like to ask you all to help work on that some in the off-season.
Understood.
All right, any other questions from the committee? Dr. Watson.
I have a question, not a little quick comment. This has been great. I remember being in the House, 12 years ago, and it being around at that time. It has certainly evolved and certainly improved, and Chairman Tillery pointed out the liability aspect. It makes me feel more comfortable, and then you're doing the medical decision making. I think that's a comfort level. I'm fully supporting this bill. Thank you for bringing it. I know this has been a work of love and labor for lots of people, and a lot of teamwork. Thank you so much.
All right.
Can I say something?
Chairman Cooper?
I
Yes.
think one of the biggest advantages of this bill are so many of the people that are having mental health crisis are over 18, but still very involved with their parents. And this would be for disabilities or for substance abuse. And yet, once they're 18, parents have no right to even know where they are, if they're in the jail, or have any contact with them, or know what's happening to them. This would allow, when they are not in crisis, if they appointed their parent as their agent, it would allow parents to be involved with their care when they are in crisis. And many of the people who lobbied for this bill do feel like that when these adult children are not in crisis, that they would pick a parent that works with them. Now, that won't always be the case, but at least it would give the parent the right to know what was happening, their medical information and all, which would be a big plus in helping one of your loved ones get care. And the other thing is so often with somebody who has mental illness, they feel they have no control over their life. This is not perfect, but at least it will give them some feeling that they have some control over their existence when they are in crisis. And I think it's the same kind of feeling we get if we have a healthcare problem and the doctor tells us you have these type 3 options and you get to choose the option that you want and make a decision about your own health care. And to the extent it can, it gives that to the person who has mental health problems. Thank you.
All right. Thank you, Chairman Cooper. There's no other questions from the committee.
Oh, dear.
And there's no one else signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by committee substitute from Senator Watson. Is there a second? Second by Senator Parent. Any discussion? All those in favor of the motion, please raise your hand. It is also unanimous. Who's going to carry the bill in the Senate?
I was hoping maybe that you would, Mr. Chairman.
I thought I already hit my quota. I think it was going to be Senator.
I think it's
Oh, I'm sorry. Senator Kennedy.
I know you're a real first choice, though. It's not the first time that's happened.
Excuse me, can I make the excuse we were so busy with the
I wouldn't even
mental
try.
health
It's too
bill
late.
on the other
Chairman
side?
Cooper,
I
it's
got
too late.
confused.
Just let it sit. Senator Tiller, do you have something you wanted to add?
Mr. Chairman, is it not true that we often get Senator Kennedy and Senator Goodman confused? So if you meant for Senator Goodman, we understand that too.
I hate to admit it, Senator Taylor. I don't even know Senator Goodman. That's it.
He's a very low key member. Doesn't say much ever, so I understand. All right, I think we're done with that bill. You do have. Thank you for your help on this. You want to knock out your other one on the agenda? If you'll
Yes,
give us
please,
1
sir.
second. The transition towards the bottom of your stack, House Bill 1092. We are working off of LC 339122S, also a committee substitute. And whenever you're ready to start on that one, the floor is yours.
Okay, about 3 years ago, I think it's 3 years ago, I think I came to this committee, and it was about the fact that across our state, that women, when they were taken to our sheriffs and in our penal system, and they were pregnant, they were still being shackled. Their feet, their hands, a chain around their waist. And if you get a pregnant woman in the second and third trimesters, because of the bulk of their body and the fact that their abdomen is growing larger by the day, they are off balance. And we had incidents where they would fall and they would lose the child. So we put a bill in that said, unless a woman was having a problem being really combative, that there was not supposed to be shackling in the second and third trimester of a woman that was in our penal system. That has gone down. It still does happen. And so the advocates brought the bill to me again, and we started talking about the whole system. We really, despite the fact that our state workers are doing the best they can, the hospital for women, which is not far from this Capitol, is below standard. And the care that it provides for pregnant women is below standard. I mean, the diet and whether they get to prenatal visits, and like I say, the diet where it's high in sodium and sugar, two things that can cause severe complications in pregnancy. And there's a high incidence of losing the infants that are delivered in our penal system, and even the mother. So really we tried to come up with a way to protect the lives of these mothers and their infants, and this is what this bill does. It says that when the judge has sentenced a woman, they're going to be in our penal system, the judge has the option to delay the start of that incarceration. The judge, at his discretion, can put certain provisions that would allow the woman to be able to delay the incarceration. This is not a get-out-of-jail-free card. It's not like accountability courts where if you go through them, you may not even have to do your sentence anymore, or you may get so much time knocked off of it. It is strictly a delay of when that incarceration starts. And it would start if the judge, at his discretion, decides the woman is not harmful to herself or to others and is willing to do this, then it would go until 12 weeks postpartum. Now, what do you do? You think, well, why didn't it start just after delivery? There is a bonding process that happens between mothers and babies. And if you look at our DFACS unit and how many children we have, anything we can do to help with that bonding period of time isn't advantageous to us as a state. Hopefully, if a mother is able to stay with her baby for 12 weeks, to hopefully breastfeed, that there will be this bonding and attachment, and we will not get children later in our DFACS unit that have what is called sort of a non-attachment syndrome, which is almost impossible to overcome. And the children often live lives of quiet desperation, or acting out, or finding themselves in our penal system. The woman can also decline to have the delay started. I would imagine that could happen if a woman was experiencing being beaten or some kind of trauma at home and didn't want to go back into a very negative situation. But it's strictly up to the judge. I'll give you an example very quickly of a couple of things that happen. One of the things the people that work in our prisons are not set up to know about complications of pregnancy, not to know about when a woman goes in labor. There's a case down, I think, in Clayton County now, where they're being sued. The woman was in the sheriff's department down there. She kept telling the people that she was in labor. They did not believe her. They let her go 11 hours before they sent her to the hospital, and the baby died. On the other hand, down in Augusta, Columbus, not Augusta, down in where Representative Jody Lott's from. Somebody got in touch with Jody Lott, Representative Lott, and there was a woman in the system down there. She was very pregnant, just a week or so away from delivery. And they went and asked the judge, and she was waiting to go on trial and all. And they asked the judge for a hearing from the judge. And he set the bond for $20,000. The boy's mother, even though they weren't sure in the beginning, then the boy had gone and there was no connection, the boy's mother had followed and worked with, been in touch with this woman. And she raised the $20,000 bond. The woman had to have an ankle bracelet. She had to, be seen by the gynecologist. And she was allowed to go home with her, I guess you'd call it a mother-in-law, unofficial mother-in-law, and was able to deliver the baby, stay home for 12 weeks, and start the breastfeeding. And then be sentenced and begin her sentencing of a 10-year sentence for a vehicular homicide when she was drinking and on drugs that killed a young person. That mother still, thanks to the unofficial mother-in-law who gives her money, calls to check in on that child every week and is very involved in keeping up with what's happening to that child, even though she is serving a 10-year sentence in our penal system. That's the difference, and it's whether it's the difference in care. I am really surprised and that we are not already having trouble and being punished federally because of the conditions in the hospital situation for our women in our state. And it's especially a problem if a woman is pregnant and in our penal system. And that's the reason for the bill, and I'll be glad to answer questions.
Are any questions for Chairman Cooper? All right, you're welcome to sit tight. We have a couple people who want to be heard on the bill. Robert Smith, Prosecuting Attorney's Counsel. Is Robert outside? We can.
I'm actually here for Robert.
Come on up.
Good afternoon.
Good afternoon.
My name is Lelaine Briones. I'm Deputy Director with the Prosecuting Attorney's Council, and I'm here on behalf of Mr. Smith. While we do have some concerns about the implementation of the bill, we do agree absolutely with the spirit as well as the intent of it. It is admirable. We're protecting a vulnerable group as well as we are protecting the state from liability, any possible liability. So those are two very good factors. Some of the things that we are concerned about simply is the issue of informed consent with regard to the perinatal health care requirement. That's going to come into a little bit of an equal protection, compelling state interest evaluation, as well as the condition for the perinatal care. It's very similar to a probation condition. And what would possibly fix that is possibly a due process, a hearing, providing the woman with a hearing to determine why she failed to have the perinatal care. So while we do agree with the spirit of the bill, there are some concerns with just the simple implementation of it, and we're happy to work with Chairman Cooper with regard to that.
And I would like to say that this is the first time that I have heard anything in dissent about the bill, is when I walked in here. And would have certainly worked. I had said to them if it's a problem, and Robert did say that he knew that I would, if this is really a problem, then I will be glad to come back and fix it. And he said he knew I was a person of my word, that I would do it.
Yeah, and I was just going to say, if there's any suggested language that you're asking for now, tell us, but we're pretty late in the game to work on it down the road. So if there's any suggested language, let's hear it today. Ms. Maisie Lane Girton, Georgia Association of Criminal Defense Lawyers.
Thank you, Chairman Strickland. I was not here earlier when our Executive Director, Jill Travis, was here and spoke with Chairman Cooper briefly. We do have some concerns, and I know we did not bring them up in the House. We've just been in too many places at one time this session. But we are happy to get with Chairman Cooper offline and see what we can work out.
Do you want to share those concerns with the committee today?
And
There's-
this is the first, let me say
yeah.
again, that I've heard
First
of.
I
time.
understand,
It
yeah.
is the first time. It's not meant to be sabotage. We just have a lot of bills that we're trying to wrangle, and we are two people. We can only be in so many hearings at one time. We have some due process concerns regarding the way that, and I'm sorry I don't have the bill in front of me because, like I said, Ms. Travis was here and we swapped out. If I could see a copy.
And before Jill left, I guess, she told me that it was all right and that she was not going to speak to the bill.
All right.
Sorry, there's a portion that allows, if you look at line 84, it begins, the sentence actually begins at line 82. If the court finds that the woman is not compliant with perinatal health care requirements, the court may rescind the deferred sentence and order confinement immediately. Our concern there is just that in the situations where the court chooses to defer that sentence and order confinement, there's no due process built in for that person to be heard on whether or not that the deferred sentence and immediate confinement should be the result.
Which line are you on again? I'm sorry.
It's okay. It starts at line 82 and goes through line 84. And I think this would tie, and I didn't speak directly to the PAC representative that's here right now, but I think this is an implementation. I mean, it sounds to me like a similar, it's just the implementation of the language. It's not, we have no concern about that. We love the idea that the court has discretion, but there just doesn't seem to be any voice for the woman should the court decide that it wants to confine her immediately.
Okay.
And there could be some reasons why there's a non-compliance that are completely reasonable and rational and legitimate, but then there's no mechanism to protect her from that confinement.
All right, let's take some questions from the committee. I'm assuming they're for Ms. Gerton. Senator Rett?
Thank you, Mr. Chairman. I was just curious, what if the person is a flight risk? Would they be outfitted with an ankle bracelet or to monitor their movements? You know how sometimes, depending on the crime, if they're a huge flight risk, I was just wondering how that worked.
Senator Rep, I think it would be, this is up to the discretion of the judge. If they thought that they were a flight risk, they would not grant them the ability to do this.
So in that case, they would, in that case, then they would be sent to prison or?
Yes, sir, they would have to serve their time and they would be sent to the, I'm not forgotten the name of the hospital we have, it's a penal hospital near here.
Okay.
Yes, sir.
Thank you.
You have a question from Senator Tillery?
Thank you, Mr. Chairman. This is on the question raised by PAC and then raised by the criminal defense lawyers on due process. This is after sentencing. It's just delayed sentencing, correct?
Yes.
So if that's the case, do we allow due process in like probation revocation cases?
Yes, there's due process and probation revocation cases.
I thought
You have a
I
right-
thought
you have
they
a right to
waived
be
that.
heard.
I thought they waived that right in lieu of the probation. I guess.
You waive your Fourth Amendment search rights in the probation does require some waiver of constitutional rights, including your right to be searched or to have your property searched. But if there is a motion to revoke your probation, you absolutely have a right to a hearing.
Getting on that point then, if this is part of sentencing, would it be part, whatever law we have in place on due process for sentencing hearings, would that automatically apply to this?
Well,
Because it says at the time of sentencing, this is envisioned to be a part of the sentencing phase. And so it seems as if whatever is going to happen at the same time sentencing's happening.
well, it is. So at the time of sentencing, if the judge has determined that the sentence can be deferred, then it's during this deferral time that the non-compliance could happen.
Right.
So, I mean, it'd still be our position that, so let's say, I mean, I don't want to, if you are sentenced on, March 1st, and you get this deferral, and then the allegation is on March 20th, you're out of compliance with your perinatal health care requirements, this would allow the judge to rescind and defer the sentence and order confinement immediately, and apparently without a hearing, because it doesn't reference back, doesn't seem to put you back in court.
Yeah.
I think I would like to think it's a minor change that could be easily facilitated by just dropping in a hearing, but.
Mr. Walker's nodding at me. Let's let legislative counsel share something with us.
Thank you, Mr. Chairman. There are different provisions in the code that simply refer to phrases such as following a hearing on this issue or after a hearing on this issue. So without necessarily having the opportunity to completely be familiar with all of the scope of this bill within the context of these lines that have been presented, inserting after confinement immediately, comma, following a hearing on the issue, would still retain the authority of the court to order that confinement, but it would only follow a hearing. And the sentencing court would then determine, I guess, the nature and scope of those proceedings.
Will you clarify where you're making the suggestion?
So on line 84, after confinement immediately, insert following a hearing on the issue.
And Jill told me that was okay. I hear having no, that,
Okay.
This,
yes.
And hearing that, Ms. Girton, do you think, I know I'm putting you on the spot, and if you say you need more time to say it, but do you think that satisfies the concern you're raising?
I think so.
Okay.
I think so.
I don't know if anybody from the Prosecuting Attorney's Council, I didn't write your name down. If you have any more thoughts on that.
No, I do think that would fix the problem. There just has to be an opportunity for the defendant who has, quote unquote, violated the terms to respond.
Okay.
Simply be heard.
I know those watching online, she said she thinks that'll fix the problem. We just have to make sure that someone that's accused of violating the requirements has an opportunity to be heard. Did I say it correctly? Let's see. Do you have more, Senator Tillery?
No, sir.
Senator Kennedy or Kirkpatrick? Kennedy.
Thank you, Mr. Chairman. So, Chairman Cooper, thanks. A couple of questions. Looking at lines 27 and 28, every woman arrested who is not released on bond within 72 hours of arrest shall submit to a urine pregnancy testing unless declined by the woman. So this would apply to all females that are arrested, is that correct? Regardless of whether or not there's an indication of pregnancy or if pregnant without knowledge of where they are within the term?
What the sheriff tells me is that they test all the women. And is he here? Of course he's left. That they want to know, that they do an initial assessment if they don't bond out. And they try to bond all the women out, especially if they know that they're pregnant. They try to bond. They don't want them in the things. And what he said to me, they do an initial assessment and then they do a test.
You're saying that like they're doing it now, or this
Yes,
is what
sir,
they
they're
want to
doing
do?
it now.
Okay, so they
So-
currently do it?
Currently, that's what
Okay.
he says. Now, he says, on top of that, that's what the current best practices is across the thing. But he says there are some places where there's, I guess, less availability of funds or where maybe they don't follow the best practices. But what he says, that is what the sheriffs consider the best practice and is supposed to be the standard practice.
Okay, and if you would look at lines 77 through 79, please. It says, during the deferred time, the pregnant woman shall maintain prenatal health treatment and assessments and shall participate in education and resource programs. Is there some language here or elsewhere that provides for enforcement of those type obligations on the woman? And how do we enforce that?
It is, strictly, the advocates and people tell me there are groups that will help these women attain this, but it's strictly an honor system, and she reports back either to the judge by email or, and I guess it could be in person in their office, if she is meeting those obligations.
And
And
assuming she's not able, or the family's not able to pay for that, who pays for all of those obligations that are now legally upon her to have to do?
that is up to the woman to be able to do it.
Where would we be if she said she couldn't afford it?
She would be, if that's what the judge required, Senator Kennedy, she would not be given a deferred sentence, and she would go into our system, which does sort of a half program of prenatal care. They don't see the doctors as often as they should. Like I say, they don't get the right diet. They don't normally get prenatal vitamins or anything like this. You know, this is strictly for the judge to make the decision. And from seeing what the judges decide, I think one of the things they would look at would be, here again, the availability of a woman to follow whatever, conditions they put on them.
Okay, thank you, Mr. Chairman.
All right. Question from Senator Kirkpatrick.
Yeah, just to follow up on Senator Kenny's question, when I was practicing and we had a prisoner in our practice, that obligation for their treatment went to the penal system, the county jail or whatever. So I'm just trying to figure out how that works with this. In other words, they're not in jail, but they're under a sentence, right? A deferred sentence. So.
Right, but if they take this option, it's their responsibility.
Okay.
And like I said, in some jails, like Cobb County, we're now doing a pretty good job of taking care of prisoners in general. They still don't want the pregnant women in our sheriff's office. I guess pregnant women scare mainly the male people that run the sheriff's facilities. But I'm telling you that when they get sent to the states, when it is when they finally get sentenced and they go into our prison system, what we provide on prenatal care is substandard. It's not like by keeping them in our prison system, they're going to get good prenatal care and good health care in the pregnancy. They don't. It is substandard. They're after delivery, they're often put in isolation. A lot of times they don't have, like I say, they're not given prenatal vitamins. There are real problems with our penal system as it reflects on pregnant women. I hate to say that it's substandard, but I'm just being honest with you.
Are there any other questions from the committee at this time? Ms. Gertens, anything else you want to say?
Well, I just based on what Chairman Cooper has said, I think that just only underscores the need for this due process at this stage, because basically the way that it's drafted currently, if someone were availing themselves of the substandard care our prisons and jails provide, they would be in violation and would be subject to incarceration. So it seems very broken to then not have any kind of mechanism for at least comparing the care they're getting to the care they would be receiving if they're going to be accused of being non-compliant out in the world where their access is probably better based on what Chairman Cooper has learned.
So what? So this would take care of it?
I think so.
Right.
All right. Thank you. One of the persons signed up to speak on the bill, Pamela Nguyen from Restore Her. Sorry, I couldn't read the last part of it. I saw Restore. It's better than my handwriting, trust me. Come on up. No, it is, trust me. Good afternoon.
Hello. Thank you, committee, for hearing us today, and I'm hoping I can help clear up some of the concerns around the issues with this bill. So I myself, have 15 years of experience as a registered nurse that specialized in women's health. I am also formerly incarcerated. I served a 78-month sentence for white collar crime in which I was pregnant. I was shackled, which caused me to fall and lose my baby, and placed in solitary confinement, which is how I came to meet Chairwoman Cooper. I was working at the time with Representative Dreyer about the issue, and I met Chairwoman Cooper at the biennial and was able to work with her on HB 345, the shackling and solitary confinement legislation. Since that time, like she stated, implementation has not been good, and we hadn't had the current data that we needed to make sure implementation went well, which was the reason that we're back now with 1092. And earlier I heard some of the things that were being asked about the bill. So basically, the part that says resources and education, there are a number of nonprofits here in Georgia, my nonprofit being one, that offer services to pregnant women, incarcerated women, formerly incarcerated women. We offer these services for free at no cost. We have always been available to help service these women. However, during COVID, there was basically no transparency, and we weren't giving any opportunities to be able to come back inside the prisons to offer the help that we give. So that was the reason for inserting resources and education into this language. So these women, if they were not able to afford proper care or whatever care they would normally get, they would contact one of these organizations, and we would help provide those services for them free of charge, or refer them to places where they could get that help. In addition to that, we also help these ladies get on Medicaid, Medicare, whatever they're eligible for, to cover their perinatal needs during their pregnancy. Also, the way that the bill is designed is that no woman would just automatically be placed in prison if she can't comply. We do understand that out of 159 counties here in Georgia, there are about 69 that don't have an OBGYN in place. And so in those cases, if a woman does have challenges seeking perinatal care or whatever it is that she needs, she is able to contact one of these organizations that provide services in order to help her get whatever services that she may need, whether that be us being mobile and taking those services to her, making arrangements for her transportation to get where she needs to go. We handle those. We are in the process now of compiling a list of all of the organizations that would be available to these women to be able to provide to the courts. So when these women are deferred, they will be able to receive that list of organizations that they have options to contact if they need help. And as far as the urine testing, the pregnancy testing goes, currently, yes, the jails do provide pregnancy testing, which they have to do if a woman is going to be in prison more than 72 hours. After 72 hours, she is put in general population, which means with all of the rest of the folks that are already incarcerated there. They must know if a woman is pregnant or not before they do this for liability reasons. So she is automatically given a pregnancy test already. So what we're asking in the bill is already being done, but in this case, it would be also to serve us to let us know that she would need to be having her sentence deferred because she is pregnant. So we're not asking to do anything that's not already being done.
All right, thank you, Ms. Nguyen. Appreciate your work on this. Any questions from the committee? You're the last person signed up to speak. I do want to hold the bill to make sure we get the language right, and so I'm going to ask that PAC and GACTL get with you and make sure we have the right language. We all want the same thing. We have the luxury of having this hearing today versus Tuesday, and so we will make sure that language is correct and have this bill back on the agenda to get it voted back out, hopefully. All right.
And if there's any other questions from anybody on the committee, I'll be glad to talk to them about it.
Yeah.
So,
all right. Thank you. I appreciate your work on this.
Thank you. Appreciate it.
All right, third on the agenda, House Bill 1216, Full Leader McDonald. If you want to come up and give us a second to shift gears again. One second, okay? All right, House Bill 1216, third on the agenda. We're working off of LC 393269S. We have a couple things being handed out to the committee. All right, tell us about House Bill 1216.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. It's an honor I've never thought I'd be coming against the Senate Judiciary as a poor country undertaker. This is
You don't have the other bills, so you don't see us again anytime soon. Yeah.
This is one of the governor's legislative initiatives, and as my daddy always told me to represent. So, as Senator Calzert, I wore my G tie today to represent the governor's hometown, but your district, sir. So, I just want to let you know that today. So,
yeah. He still doesn't like your bill, I don't think, but we'll see.
Well, I was going. If Chairman Tillery's here, I'd picked a new doctor to do my next physical too, but since he left. But House Bill 1216 it's a recurring issue that's growing across the state of Georgia, dealing with our law enforcement. This bill came to us from our Georgia Department of Public Safety, and before you is all their stats that they've done over the past few years on the fleeing and looting of our law enforcement around our state. And the ones you have before you is only our state patrol, and it shows years by years. There's going to be a little difference in 2019 because that was a year that our state computers were hacked, and so there is a decrease, which is an inaccurate number, but they do have the numbers that they were able to put together for that year. The main part is when we get into the fleeing and looting is that I had the personal experience. I've ridden with the Nighthawks twice, and it was an experience of what goes on in our city. And we have 3 zones that the Nighthawks work in: a southern zone, central zone, and of course the northern zone being mainly in the city of Atlanta. Currently, the city of Atlanta has a no chase policy, so the Georgia State Patrol is the agency that has jurisdiction looking for those that mainly just impaired drivers. They're not a speed enforcement group, but they are looking for the drivers that are in our city that are impaired. What happens currently that we're looking into this legislation is increasing the minimums, only the minimums of the first, second, and third offenses. You'll see in each offense, these are still aggravated misdemeanors in the first, second, and third. On the fourth conviction of the fleeing and looting, you'll see it is an automatic felony. Along with that, it's important to note that current felony fleeing and looting does not require imprisonment, but it is that aggravated misdemeanor. And this is an error in the code that is resolved in this bill. In your fleeing and looting that this bill does clear up is that will automatically make it even on your first offense if you do certain things as following, and adds to the list of causing the accident of another vehicle, driving on a sidewalk, overtaking a stopped school bus with its signals out, laying drags, reckless driving, reckless stunt driving. Those will be automatic felonies under this current bill. Also, currently under the state statute, in the fleeing and looting of an officer, only alcohol, under the impairment of alcohol of 0.808 or greater, will consist of a felony. Under this current bill, it will add any other substance that you might be on, whether it's marijuana, prescription drugs. It will make it a felony. And lastly, under this bill is the impersonation of a police officer. Having a blue light, you had to be approved by a sheriff or your local law enforcement to be able to have a blue light in your vehicle. But never has it ever been codified into law that using a blue light to pull over someone impersonating an officer was a felony. So we did codify that part into law. With that, Mr. Chairman, I'll be glad for any questions.
All right, any questions for Representative McDonald? Question from Senator Kennedy.
Mr. Representative, thank you for bringing this. I'm just curious, in the workup of the bill and maybe the hearings that y'all had, what was the thinking behind it going to a felony only after the fourth conviction or the fourth independent incident rather than maybe the third? Or what was the thinking behind that?
Well, you want to give everybody a chance. Normally, Senator Kennedy, that if you look at the other things we're adding, causing the acts of another vehicle, driving on a sidewalk, laying drag, reckless driving, that's happening, whether it might be the first, second, or third now. So we are adding these, and that will make it an automatic felony if you do any of these others. So say you're going down the road and you do the O.J. Simpson drive where you stay at 55 for 4 hours, that's just fleeing and eluding. So that might be O.J.'s first offense with his buddy driving.
Okay, so maybe I misunderstand the bill because I thought that those other things have to be, like driving on the sidewalk, have to be coupled with eluding police officers in the same instance. Is that, have I misunderstood this?
No, you can flee and elude without doing, causing an accident, laying drags and overtaking and stuff. Right. So we're giving opportunity for just fleeing and eluding, which would be an aggravated misdemeanor. Now, if you do any of these other list of offenses, that will automatically make it a felony. Even
if you're doing those offenses while you're not fleeing and eluding?
No, all this
they have to be coupled with fleeing and eluding.
Yes, correct. This bill is only for fleeing and eluding.
Okay.
Yes.
So back to my question. So the person it's elevated to a felony only after the person has been convicted on 3 independent instances of fleeing and eluding the police, and they might have been doing some other offenses as well, but it would go to a felony on the 4th time of the person doing this having been convicted 3 times prior.
Yes, sir.
Right?
I'm going to turn to my first sergeant back here. That is correct, and it's on the 4th.
Okay.
On the 4th time without any of the other.
Do you want to come up? You can introduce yourself for us.
My name is Sergeant Vince Mooney. I'm with the Georgia State Patrol. I'm the legislative liaison officer for the department. As to your question on the fleeing and attempt to elude, on the third bill, on the third time, without any of the other consequences of driving on the sidewalk or anything like that, at that time, that would be the 4th one would be a felony. If any of the other offenses while they were fleeing, even on the first time, that would automatically be a felony on that.
I'm sorry, which time?
On the
first time,
driving
okay.
on the sidewalk while fleeing and attempt to elude.
Okay,
gotcha. That would automatically get to a felony.
Okay. One other follow-up, Mr. Chairman, please. Is there any provision in this code section or other code sections where if someone is concerned and wants to continue on driving safely to a lit area because of, and it's not so much in the news as it has been in years past, of people impersonating police officers and women being targeted for being stopped by people who are impersonating police officers, for them to continue on to a lit area or continue on to a police station. Is there anything in our law that affords a woman that kind of safety option but not fall prey to the eluding charge?
To my knowledge, that's allowed as long as they, for example, slow down, turn on their flashers, acknowledge that there is a law enforcement officer behind them. Yes, they can proceed to a safe place without being charged with fleeing and attempt to elude.
Okay, thank you.
Yes, sir.
Any other questions from the committee? All right. We have a couple of people signed to speak on the bill. I don't know if it's Mr. Smith again from Prosecuting Attorney's Council. If y'all want to step aside for a second. Sure.
Welcome back.
Robert Smith, Prosecuting Attorney's Counsel.
Roberts, welcome back. Miss Smith, right?
Actually, Lelaine Brian is Prosecuting Attorney's Counsel. We simply say that we have worked with Georgia State Patrol, Legislative Council, and we support this bill.
Okay. Thank you. Any questions from the committee? All right. And we actually have Ms. Jill Travis, Georgia Association of Criminal Defense Lawyers, filling in for Ms. Maisie Lynn that signed up.
We're doing cloning today.
Mm-hmm.
Good afternoon, members of the committee. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. If punishment increased and worked in deterring crime, we wouldn't be changing these things all the time, right? We wouldn't, if deterrence worked because we increased the penalties, I mean, that's the idea, right? We're going to stop the crime from happening because we're going to increase the penalties. And what this bill does is, I mean, what we might say is, Mr. Accused, when you were fleeing from the police, had you known that the punishment was going to be 30 days instead of 10 days, would you have stopped? And I'm pretty sure the answer is no. And so this is one of these unique crimes where there is no, this is a mandatory time in prison, time in jail, and, I think it's days, not subject to suspension, and a mandatory fine. And increasing it substantially on all of these offenses. I mean, y'all can read from yourselves, but on the first 10 to 30 days, and the punishment from $500 to $1,000. And I'm not going to read through it because I know that you all have looked at it as well. But we just ask you to consider that sentencing serves two primary purposes. One is punishment, and two is incapacitation, so that you can take them out of the system for a while. And the statistics show that the more severe punishments don't actually prevent crimes. It's actually sometimes a shorter stint that can get somebody's attention. I know that may not make a lot of sense, but any of you that listened to the testimony during criminal justice reform learned how certainty in punishment is what actually deters crime. And actually prisons have exacerbated recidivism, and that another factor that comes into play is a person's age in committing a crime. So I understand that this is the governor's initiative. I understand that this looks like it's accomplishing a lot, but we don't think that it is.
All right. We do have a question in the committee. Senator Parent.
Thank you, Mr. Chairman. Thank you, Ms. Travis. I was just thinking through a lot of the high-profile cases where people have fled. Wouldn't it be the case that they're either they just kind of panic? A lot of times they've got some other outstanding child support hearing, or they're intoxicated.
Yeah, and that's one of the things that's been added to this bill, is that if somebody is DUI, that will increase the penalty to automatic felony.
But my point is, wouldn't it be the case that they're having bad judgment because they're intoxicated in the first place?
Yes, I have to say, in my experience, I have not actually represented a lot of people that have fled from the police, and certainly have seen it on television where people are fleeing from the police. But just this, I think my point is that this sounds really good, but it's going to be harsh to the system. It's going to put a lot more people in custody for longer periods of time. The amount of people that we have on probation in Georgia is is super high for traffic offenses. It disproportionately, traffic offenses, like when you're talking about a minimum $1,000 fine, disproportionately affects minorities, and being able to get out of the system of having probation and having this regime. And you're also, you know, what you do is, if they have a job, which we hope that those are the supports, you know, housing, jobs, community, that people need to support themselves, you're cutting it off more, and quite substantially. I don't know if I answered your question. I'm sorry.
Question from Senator Kennedy.
Thank you, Mr. Chairman. So, Ms. Travis, it strikes me we're talking about some pretty seriously bad behavior. We're talking about folks that are eluding the police, who are trying to stop them as a part of public safety for the safety of the rest of us, and that some of these instances involve really dangerous, really bad conduct by the people that are trying to escape the police, who are trying to do their job to keep the rest of us safe. And under those circumstances, if your position is that, well, increasing the fines and penalties just is not the way to go to try to increase public safety, then from a public policy standpoint, what would you recommend that we do?
One of the things that you can do is increase police presence, so that there's a perception that criminals will be caught and will be punished. So community policing is also another feature.
But Ms. Travis, I hate to interrupt you, but I don't want to hold us here too late. That really doesn't help in a situation where someone's in an automobile driving probably at a high rate of speed, trying to elude the police, who are trying to do their job to keep the rest of us safe. How does police presence make a difference? They're fleeing from that police presence. So why does more police presence somehow deter the conduct that we need to make sure our statutes reflect to support the people that are trying to keep us safe?
I'm not starting at the point where the bad behavior is taking place. I'm starting before that.
Okay.
The
All right.
the point that you're making is I think, or that I'm trying to say, is that when the bad behavior is going on, the fact that they're going to get 10 days versus 30 days, and they're going to get $500 versus $1,000 is not part of the mindset. It's fixing it on the front end.
Thank you. I appreciate that, but just final comment, Mr. Chairman. If that were the case, then that would require all of us to communicate to future potential criminals, here's what your fine or punishment may be, and I don't know that that's reasonable for us to try to do to try to help keep us safe. Thank you, Mr. Chairman.
All right, no other questions from the committee. Thank you, Ms. Travis.
Thank you,
That's
members of the committee.
everyone that signed to speak on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Kennedy. Is there a second by Senator Kirkpatrick? Third, any discussion?
Yeah, discussion.
Hold on, Senator Tillery. I'll call on you.
If she wants to go first, that's fine. I'm going to propose an amendment.
Okay, let's do discussion. Senator Parent.
Okay, yeah, mine's just discussion. Thank you, Mr. Chairman. I was just going to say that it really just strikes me that in this crime in particular has always been a little bit baffling to me, because it's so obviously totally irrational. You know, it's obviously clearly bad judgment to drive away from the police, to try to elude them. You're going to be caught. Your punishment's going to be worse. All that has always been totally obvious. And so I just really don't feel, I have to agree that I don't think it's that additional punishment is going to change that clearly irrational behavior. And I know that's not satisfying, because I actually had the same question for Ms. Travis that you did, Senator Kennedy, about like, well, then what should we do? Because it is quite dangerous. But I can't in good conscience vote yes when I do not think it's going to have an impact on what is behavior that clearly is not being underpinned by any rational decision making. But I'm very curious to hear the amendment.
All right, thank you, Senator. Any amendments, Senator Tillery?
Thank you, Mr. Chairman. I appreciate events and the things you spoke back to Senator Kennedy, but also understanding that if we don't have that exception in code, that it's not allowed to be a defense in court. I would just suggest that our committee should add the language that was discussed with Senator Kennedy and others as a defense. And my suggestion is we go into line 20 and say, an individual who reduces their vehicle's speed, comma, turns on the vehicle's flashers, comma, and drives to a lighted area before stopping shall not be deemed to flee or attempt to elude a pursuing police vehicle, period. We've said that that's the law. We need to make sure that it is the law.
Other Senator Kennedy?
I'll second it or let my colleagues second it, but I agree with that, and I think that's an excellent suggestion.
What if someone tries to raise this defense after they've already been eluding the police, and the excuse is, well, turn the flashers on as I just finally saw you and pulled to the side? I mean, does this create more issues? Because you already have to prove the intent. You already got to prove the intent of someone trying to elude an officer. Just want to throw that out there. Are we really going to muddy up the water and trying to...
If you want to put a speed on it, Mr. Chairman, I'm happy to take an amendment to the amendment. If you...
Or could I suggest this? What if we inserted the word immediately somewhere in your verbiage that indicated at the time the police are engaging and trying to stop the person?
I don't think Michael got my verbiage, but that's fine. I can. It would then say an individual who immediately reduces the vehicle's speed, turns on the vehicle's flashers, and drives to a lighted area before stopping shall not be deemed to flee or attempt to elude a pursuing police vehicle.
All right, and there is a second, apparently. I guess everybody but me. Okay. Any discussion on the proposed amendment? Does Ledge Council have a comment?
I would need time. I can't take that on down that quickly.
All right, do you want to read? If we're going to do this, let's repeat it one more time, Senator Tillery.
Adding to a new sentence at the end of line 20 that would say, an individual who immediately reduces their vehicle's speed, comma, turns on the vehicle's flashers, comma, and drives to a lighted area before stopping shall not be deemed to flee or attempt to elude a pursuing police vehicle.
All right, does anybody, the author, anybody from the governor's office have any comments?
I would like to.
Move, step back up. Yep.
I would like to possibly add to, when he talks about reducing the speed, to the reducing the speed of the posted, to the area of the posted speed zone that they're in. I think that would be appropriate to look at is
All right.
Because if you're reducing from 90 to 70.
Understand. That's fair. So then you would want the sentence to read, let's go. An individual who immediately reduces the vehicle's speed below the posted speed limit, turns on the vehicle's flashers, and drives to a lighted area before stopping shall not be deemed to flee or attempt to elude a pursuing police vehicle. Does that help with your concerns, Representative
Myers?
McDonald?
Thank you, Chairman. Just looking to State Patrol in terms of how that language kind of mirrors how policy is right now, is that generally in line with how procedures?
Cool.
All right, does everybody understand the amendment? Any discussion on the amendment? All those in favor of the amendment, please raise your hand. I'll let you hold on this one since you just walked in. Any opposed? All right, the amendment carries. Any other amendments? All right, we're back to the underlying bill. Motion to pass now as amended by the committee. All those in favor of the motion, please raise your hand. So we have 6. Any opposed? We have 3. All right, motion carries. Thank you. Is Senator Hatchett carrying this one? Representative? Okay, thank you. All right, Representative, I almost called you Senator. Representative Gunter, if you want to come up, let's do House Bill 554, third from the bottom. I'm just trying to continue to confuse you all on where we're going. Give us a second to get the bill. We are working off a committee substitute 442094S. I think you have a partner, Edward Lindsay, join you as well. Tell us about House Bill 554.
All right. Thank you, Mr. Chairman. Members of the committee, this bill was brought over to this committee in last year's session, and at that point I thought it went dormant and stayed here. In the last week or so, it has resurrected itself, and so I have Mr. Lindsay here with me to help me with some of the changes that have occurred in the bill. Also in sections, Part 1, Sections 1, 2, and 1.3 is language that comes from the clerks of the court. And it basically is modernizing the language. It was 25 years ago or so since I did my last title search, and back then there was a Liz Pendon's book, and now I understand that they don't do it that way anymore. Right. So I would be lost if I were to try and do one today. So this takes that language out, and then it also in the Section 1.3 requires the cancellation by the party that initiated the Liz Pendon's. And so I'm going to turn it over to Mr. Lindsay at this point, because the next section is very similar to what we had when it went dormant, but there have been some changes to it, and I think there may be some additional changes.
Good.
Thank you, Mr. Chairman.
Are you going to talk about what a Liz Pendon's is?
Yes,
okay.
I want to talk about the Liz
All right.
Pendon's, and Michael Holloman is here to talk about the clerks, because the last time I did a property title search, it's been 20-plus years as well. So we're going to turn that part over to Mr. Holloman, who's here to sort of outline that as well.
Well, don't take 20 years to tell us about it.
No, I'm going to be very short, hopefully, because I will tell you, while we've been waiting for a year to get this passed, we've worked very closely with property lawyers in the state, and I'm very grateful to their input off and on for the past year, leading up to this week, which is leading up to this afternoon, which led up to a couple of more discussions in the back. And if you accept the tweaks that I'm going to propose to you in a moment, you cut short 2 witnesses who will now be okay with the bill.
I like that. Okay.
Anyway, what this section does, Mr. Chairman, and first off, my name is Edward Lindsay. I'm from the law firm Denton's, and I'm here representing a gentleman by the name of Ryan Milsap, who is a large property owner in this state, who's dealt with this issue as part of his business. And what this bill simply does is it puts into law an avenue for a property owner in which a lis pendens has been filed in a lawsuit that believes that the lis pendens was not properly filed, and simply just allows for an avenue for him or her or it to file an objection, to file an intervention and file an objection, and have the court make sure that the lis pendens was properly filed. In substance, that's it in terms of this section. What it does is simply, once the lis pendens is filed and the property owner wants to object, if they're not already a party to the case, they have a right to intervene into the case and file an objection. That's essentially what the bill does. At the suggestion of some very good lawyers, they wanted to make sure that should a party disagree with the decision to either continue the lis pendens or to withdraw the lis pendens by the court, that someone would have a right to a discretionary appeal. And so that's essentially what the bill does. We have out in the hallway, like I said, and this has been an ongoing discussion with property lawyers, they've recommended some tweaks at lines 67 to 69, to section B, and I have as good a clean version as I can. Hopefully legislative council can read it. I've tried very hard. if you will follow along, what we would recommend, and the property lawyers thought this was a good idea, is that any person with, and add the following line, a claim of a legal or equitable interest in such real property shall have the right to intervene and file a motion to object in the civil action to the filing of the lis pendens, and if so filed, the court shall review and make a determination within 30 days unless otherwise extended by the court of such filing as to whether, and continues on. Basically, the addition is the legal and equitable part, making it very clear that there needs to be an intervention if it's a non-party, and simply giving the court some discretion should it not be able to make the ruling within 30 days. And those of us who've appeared in court know sometimes judges can't get to something in 30
Will
days.
you talk about the Second Amendment real fast again after days on line 69? What are you adding, unless otherwise?
Oh yeah, after days unless otherwise extended by the court.
Okay. And so you'd have a claim of a legal or equitable after.
Yeah, strike and
after
All right,
between
I'm
with
sorry,
and
Mr.
interest.
Chairman, on line 67, strike and insert a claim of a legal or equitable.
And then you'd have.
And then at the end of that line, strike by filing of, and insert to intervene and file.
Okay. And then line 69, between days and of, unless otherwise extended by.
By the court.
The court, and you would strike.
Don't strike anything, just
Anything,
add the
right.
language. That's it, Mr. Chairman. That's essentially what the bill does. It allows a property owner proper due process if should they believe that a mistake has been made in terms of the filing of a lis pendens. And, you know, I know the hour is late, but so I'm going to actually cut short perhaps my client's time testifying, if you allow me to simply just sort of give them an example. They did, in his case, he had a piece of property that should not have had a lis pendens attached to it, but it it tied up his ability to get proper funding for a particular project in the state that had a great benefit to the people of the state of Georgia until it finally was able to clear up. It took about 3 years to clear up something that should have been able to be cleared up much quicker. In the end, the lis pendens was lifted, the mortgage funding was provided, and they were able to move forward. But all this does is give any party that ability to simply come before the court.
And a lis pendens is simply where you have a lawsuit involving an interest in property, and the property has a lien on it, and that's just why the lawsuit's pending. And there's not really a current process by law to address that and to try to have that taken off, and that's what you're doing with this bill.
That's all we're doing.
It's a notice provision.
It's simply a notice provision, but a notice provision that could limit someone's property rights should it be, and which is bad if it's not proper.
It won't be to sell your property or take a loan out if that's pending. Senator Tillery.
Thank you, Mr. Chairman. Thank y'all for bringing this bill. I've wondered about some of these in the past too. Let me make sure I understand it correctly though. You can still file the lis pendens. What this does is essentially it accelerates a hearing on whether or not the lis pendens was proper.
Correct.
So that if it wasn't, the parties can still go about their normal lives while the litigation churns.
Correct. Correct. Okay. And I want to add that my thanks to the various property lawyers, and there have been a lot of them that we've worked with over the last year to help. Everyone has been in general agreement as to what we were trying to do, was trying to make sure that the procedure was correct in terms of how it actually works in court. And those of us who go to court a lot understand that. But so I do appreciate their willingness to sit down with us and work with us.
Well, there were others that signed up to speak. Did Mr. Milsap still want to be heard, or the other two lawyers?
I think you're good.
I'll call you up if. Okay. Just want to make sure. Mr. Almabeck, Mr. Chanis, and Mr. Milsap. Anybody else want to be heard?
Yeah. I think my client would be good based on that, given the fact that the property lawyers have worked so well with us. And
okay. Any questions from the committee? All right. At this point, what's the pleasure of the committee? Okay, come on up. What's your name? Oh, Chanis. Okay, come on up. Sorry.
Come on up, sorry.
And then we'll go back.
Yes.
Good afternoon, Mr. Chanis.
Good afternoon, Brett Chanis. I am a real estate litigator. Have been practicing in this field for my entire 10-year career. work with list pendants day in and day out. I file them with respect to cases where I represent the plaintiff and defend a number of cases where the plaintiff has filed a list pendant. So I'm very familiar with the existing process for recording list pendants and for getting them removed from the record. And I will say that based on Mr. Lindsay's comments and the proposed amendments, I am a lot more comfortable with the bill. But there are still a few concerns that I see with this that Mr. Lindsay and I have discussed and I think are going to be worked out, but just want to bring them before the committee to make them known. To begin with, so that everybody understands what a list pendants is, just want to correct one thing that was said previously about a list pendants being a lien on property. It is not a lien on property. A list pendants is simply notice of pending litigation. So that everybody knows in clear language, the Georgia Supreme Court put it out there all the way back in 1948. Just said a list pendant simply gives notice to prospective purchasers that a lawsuit involving realty has been filed. It does not prevent the sale of the property, nor is it a lien on property. And once a list pendant is recorded, however, there is a statute that provides that any purchaser takes subject to the result of the litigation. So it is a way to protect somebody once they file that lawsuit from the property being sold to a potential bona fide purchaser. Now, the issue that I'm hoping to get worked out with the stakeholders here is the requirement that a bond be posted in the event that the court deems, let me step back. The current bill provides that an interested party can object to the list pendants, and the court, although it finds the list pendants to be proper, can still order that a bond be paid or posted for that list pendants to remain. The concern that I see with that through my practice is that, as I just said, a list pendant is not a lien, and it is not a court order that restrains anybody from doing anything. And a bond, if you look at it in this context of a civil action, if you look at the something like OCGA 91165, a bond is security in the event that somebody has been wrongfully restrained from doing something by a court order. But since a list pendant is not a court order, there are some questions that come to mind about what that bond payment is there for and what a party who claims to have been damaged could claim. Now, speaking with Mr. Lindsay beforehand, I'm hopeful we can work these out and come to an agreement as to language that will satisfy everybody that's interested in this bill, which is a lot of people. There have been a lot of real estate lawyers who have been interested in this bill and have been watching it closely. And I'm hopeful that this bond language will be worked out because certainly we want to get that worked out and not have judges led astray by this requirement and not really knowing what to do, quite frankly, once this bond is posted. Can these parties who intervene claim damages? Does it have to be a subsequent lawsuit? I think there's some procedural issues that could be worked out, but hopefully we can do that.
Thank you. One question on that, and I use the word lien. I know it's not proper legally, but in my experience, and I've been on both sides of these in litigation, for someone that has this entered on their property, in practice, it does prevent, most times, any sale of the property, taking out a loan on the property, and so it does, in essence, feel like a lien to an individual. I think you'd agree with that in a lot of situations. I wonder if what you're saying, if the court should be considering in the bond part, line 74 and 75, whether that's the case, whether someone could show in court that this is restraining my ability to do this with the property, therefore there should be some sort of bond post. Is that kind of what you're saying ought to be considered in this situation?
I think there needs to be some sort of guideposts for the court, or at least some sort of perhaps a cause of action that's established within the abusive litigation statute. Mr. Alembic and I, speaking beforehand, had discussed whether a party that claims to have been damaged by a list pendant could bring a cause of action for abusive litigation. But currently, the abusive litigation statute, as written, allows for a party to bring a cause of action if they've been damaged by something that's been set forth in a pleading, which is defined as a claim, as a complaint and answer, a counterclaim, a cross-claim. A lis pendens is not within that definition. So there would have to be some additional amendments to other statutes to allow that cause of action to be brought.
All right, any questions for Mr. Chanis from the committee? All right, thank you.
Thank you.
Did Mr. Allenbeck want to be heard? That was you. You said no, right? Just want to make sure I didn't miss anybody.
Mr. Chanis basically reflected
my
sentiments. I do think the abusive litigation statute might be worth looking at for the purpose of actual damages issue that might be presented. I think that's a more sensible approach, but that bill's not before this committee.
Right, maybe a separate matter than what we can deal with here. Anything else, Mr. Lindsay or Mr. Milsap?
Perhaps Mr. Milsap, just very quickly. I know the hour's late.
Okay.
Mr. Chairman, thank you. My name is Ryan Milsap. I'm a property owner here in Georgia. I've owned many thousands of acres, many millions and millions of square feet of real estate in the state. I was a professor of real estate at the University of Southern California for 7 years. And what I can tell you is that on a de facto basis, on a functional basis, a lis pendens functions like a lien. And it's used very abusively many times by litigators as a prejudgment attachment and as a way to create leverage against someone who's defending a lawsuit. And I've had that happen to me in very unfair and unjust ways. Because what you have to understand is that when a lis pendens is put on a property, you cannot refinance that property. You cannot sell it. You can legally, you could sell it, but functionally in a marketplace, no lender will go near that piece of real estate. Functionally in a marketplace, no buyer will go near that piece of real estate. So right now, the function which the former gentleman explained of just being, quote, a little notice to the world, I've actually heard those words used in court. Oh, it's just a little notice to the world. Well, that's not what it is. It's unmerited leverage. And that's what we're trying to fight against here. We're trying to fight against someone coming and being able to put an attachment and put a blemish on a piece of real estate that they don't own, that they're claiming interest in, but that hasn't been proven. And I know this is an esoteric area of law, but we've worked really hard on this. We're trying so hard to make this something that's less abusive, and that's the goal here.
All right, you have some questions, Senator Kennedy.
Thank you, Mr. Milsap, for being here, and I appreciate your comments on that. And I would just add, too, I think something you're going to agree with, and that is there's also no rational relationship between the notice, that is the lis pendens, and the amount of the claim associated, presumed claim or presumed amount associated with the presumed claim, and the value of the property which has now been liened or whatever we want to call, correct?
That's exactly right.
Thank you.
Another question from Senator Tiller.
Thank you, Mr. Chairman. Thank you, Mr. Milsap. I have a question. I don't think that this bill does that, but I just want to make sure you agree with me. In some instances, you have you may file a lis pendens to keep people from getting rid of all their assets while they're in the middle of suit. This doesn't stop that, right? It just would accelerate the hearing on whether or not that lis pendens could be used for that purpose?
That's correct. I mean, what it is I'll give you an example. I had a piece of property that's a $120 million piece of property that somebody put a lis pendens on. It made it where I could not refinance the property. It forced me into a very difficult position where the property was then going to be foreclosed on if I didn't do a deal with somebody that was claiming a lawsuit. And so I had to do a deal that was with unmerited leverage, because otherwise I could lose a $120 million piece of property. Is it possible? I couldn't sell that property during that time, but I couldn't get a hearing for 9 months.
Yeah,
right.
That's the point. Because I've been on the other side where we were very concerned that Party B was going to just sell everything out and leave us with an empty bag. But this doesn't stop it. I can still do that. It just accelerates your justice and really justice for my client as well.
I mean, the key is we're just trying to make it to where it's not abused, right? I mean, everybody needs to be treated fairly. So if somebody has a legitimate claim to a piece of real estate, then they should be able to make that claim, and that claim should have some teeth. But the problem here is when people are making claims where they don't actually have legitimate claim, and it creates unmerited leverage.
For another claim. Gotcha.
All right, any other questions from the committee? All right, that's everyone that's signed up to speak on the bill. What's the pleasure of the committee?
Motion to pass, Mr. Chairman.
Motion to pass by committee substitute from Senator Kennedy. Is there a second? Second by Senator Hatch. Any discussion? All those in favor of the motion, please raise your hand. Up. No, you're right.
Excuse my.
It's late. We're talking about Liz Pendens. My head's. Let's back up. Before we vote, are there any amendments? There was an amendment suggested by Mr. Lindsay. I think everybody agrees with. I wrote down after, on line 67, after with, a claim of a legal or equitable, it would be inserted between with and interest, strike and. And then also on line 67, would strike by filing of and say to intervene and file. Yeah, unless
Legal or equitable
interest.
in such property shall have the right by.
Let me bring your mic on.
Okay. I'm just making sure that I'm tracking
Yeah.
with you. Any person with a claim of a legal or equitable interest in such property shall, and then I was following back with you.
Yeah, shall have the right, and then striking by filing of to intervene and file.
Okay.
All that on line 67. Mr. Walker, is that correct?
Yes.
Let's just do one of these at a time. Is
Gotcha.
everybody clear on that proposed amendment? Does somebody want to offer that amendment on the committee? It's offered by Senator Hatchett. Is there a second?
Second.
Second by Senator Tiller. Any discussion? All those in favor of the amendment, please raise your hand. All right, it carries unanimously. Now let's look at line 69. And I believe it's between days and of. It would say unless otherwise extended by. And so it would read, court shall review and make a determination within 30 days unless otherwise extended by. I didn't do
Mr.
that
Chairman.
correctly. Yeah, if you'll, Mr. Walker.
If you would just make that adjustment, that clause would be inserted after such filing.
After such filing, that makes more sense. So let's go back. It would read, court shall review and make a determination within 30 days of such filing unless otherwise extended by the court as to whether, that's so it should be correct, unless otherwise extended by the court.
Okay.
Is everybody clear on that proposed amendment? Is there somebody who wants to offer it as a motion?
So moved.
So moved. Senator Tillery, a second. Second, Senator Kennedy. Any discussion? All those in favor of that amendment, please raise your hand. It's also unanimous. Back to the underlying motion to pass by committee substitute as now amended. All those in favor of the motion, please raise your hand. Now we're there. Unanimous. Okay. And who is, you're the author. Am I carrying it? Or Senator Hatchett's carrying it. Perfect. Okay. Yeah, bring it on up. All right. Thank you.
Thank you very much,
All right.
Senators.
Thank you all. Do y'all want to take a 5-minute break? You want to keep rolling? We have a few more bills. All right, let's take a 5-minute break. All right. We'll stay as long as we keep a quorum. All right. We want to try to get through this agenda. We have 3 bills left on the agenda, but at the same time, we do have Monday and Tuesday. We're just trying to get through this committee, but if we need additional time, we'll be able to continue on that at that point. But I know we're going to lose a quorum at some point soon. So let's get going again. Let's start back. Who probably thought they were going first because they were first on the agenda. You're first out filing your bill in the House, but you weren't first in Judiciary today. But House Bill 1, come on up, Representative Bonner. Give us a second. Define the bill that was at the top of the stack originally. We are working off of the original LC, House Bill 1, LC 500337S. Representative Bonner, the floor is yours.
Well, thank you, Mr. Chairman.
Let me get your mic on. Now you're there.
There you go. Thank you, Mr. Chairman. Thank you, members of the committee. I appreciate the opportunity to present House Bill 1. For those of you that were on this committee in 2020, this may seem familiar to you. This committee and the Senate had passed out Senate Bill 318 by Senator William Ligon at that time. So this bill is a scaled down version of that bill, but contains a lot of the same language. House Bill 1 will protect and clarify the First Amendment rights of our students and the members of our campus communities on our public colleges and universities. The bill seeks to accomplish this in 2 ways. First, by protecting what students may say. Second, protecting where they can exercise that free speech. It protects what students can say by ensuring that our public universities and technical colleges do not ban any expressive activity while on campus, so long as their conduct is lawful and it does not disrupt the functioning of that college or university. It protects where they can speak by banning so-called free speech zones or areas of campus that are designated for free speech, rather than all of the commonly accessible areas of campus. It also clarifies that universities can impose published, reasonable time, place, and manner restrictions on speech that are content neutral and not directed toward a specific group. That, Mr. Chairman, is the summary of the bill. I'll be happy to stand for any questions.
All right, we have a question from Senator Parent.
Thank you. Thank you, Representative. I am curious what the issue is attempting to be rectified in this legislation. You didn't mention that.
Certainly. Thank you for that question. So one of the byproducts of this will to eliminate the lawsuits that tend to occur against our university system. So it will certainly reduce those number of lawsuits. It will reduce the cost to the taxpayers. And then, of course, more importantly, it will certainly reinforce those First Amendment rights that we believe that are due to those universities and colleges.
So do you have an example of the lawsuits?
Yes. So there have been a number of lawsuits over the years. There was one that was just adjudicated back here recently. It was, and I'll kind of butcher the name, but it's out of Gwinnett College. It's Uzugbunum v. Przewalski. It was a free speech case that went to the U.S. Supreme Court that was recently adjudicated in 2021.
And that was a 2021 case. Okay.
It was adjudicated in 2021. It was initiated prior to that.
Well, in that vein, I noticed the definition of campus community, and it seems like anyone that has a connection to the campus, like a legitimate, connection, student administrator, faculty and staff, but then anyone that they invite are protected under this?
That's correct. The invited guest, I believe, is what you may be referring to.
Yes, they're invited guests online.
That's correct, Senator. Yeah, so the language in that comes directly from an 11th Circuit Court decision recognizing that a campus limited public forum includes students, faculty, and their invited guests. So this is an instant where throughout the bill you'll see we tried to use language that came directly from various court cases.
But I mean, how broad is that? Is that as broad as it sounds?
Well, it is certainly broad in a sense that if someone is a member of the campus community, they would be able to invite someone on to be their invited guest onto the campus. That's correct.
So they could invite what if they invited, so it's not like they're getting clearance, there's not a permit, there's not an invited speaker, it's just like they invite a couple people on and they're some kind of terrorist group or hate group or something?
Well, I would, of course, if someone was a terrorist group, that would be unlawful activity. So that would certainly.
Not unless they were, I mean, they could, if they were committing a crime, it would be unlawful. But if it's speech oriented, it would seem that your bill would protect them.
Well, the bill seeks to protect free speech and First Amendment rights. It does not protect any unlawful activity.
Well, but I'm talking about them speaking and what they say, not a crime. You see what I'm saying?
Again, the bill itself protects free speech. So anything that is deemed to be free speech would be protected.
So it also says, first of all, there's, I think, conflicting language in here because you've got some like carve-outs and other things that are very confusing to try to follow as it relates to what is free speech and then what is not free speech and what speech is protected and then what speech is then disallowed in response to the speech. So all that I think is pretty confusing. And to your point, if we're protecting the speech of the hate group, or say it's some kind of group that's very controversial, and a counter-protest forms, I noticed that there's language in here about, well, they can't materially or substantially disrupt the activity, but they are allowed to, I believe, make minor, brief, or fleeting nonviolent disruptions of events that are isolated and short in duration. So how does that not hinder the free speech of the other people who are also, maybe they're students, or maybe they just invited a whole bunch of people because they heard this other group was coming, and then all those people would be justified under your bill being there and also have a right to free speech?
So yeah, thank you for the question. And I think what you're describing is what's commonly referred to as the Heckler's veto. So I will use an example that we may find in a committee hearing like this, where we may have two opposing sides, and during my presentation, someone in the back were to make a comment of about something disparaging or just a single outburst, right? So that would fall under free speech. Now, if that person stood up and just continuously began to talk and disrupt and just flat out did not allow me to finish and completely disrupted the meeting, then that speech would not be protected. And for instance, under that circumstance, that individual would be removed.
So if the individuals that claim protection are like 3 individuals, but their speech is so offensive that a much larger group gathers to counter-protest them, are those individuals, say they're not like trying to materially disrupt it, but they're just speaking normally? Would they have to do they have to stand silently? Because that would seem to violate their free speech rights. Would they have to whisper?
No, they would not. But in those cases, the campus has the ability to come in and keep those separate, so it doesn't escalate into anything that would fall into a category of unlawful. But it does allow for a counter protest. The bill does allow, again, to anything. It does not allow anything unlawful. So the university would be able to come in and separate those groups and allow that protest and counter protest to take place.
I might have a few more in a minute, but I'm going. Yeah.
Any other questions from the committee for Mr. Bonner, Representative Bonner? All right.
Well, actually, if no one else has any, I do have.
Well, there's other speakers too,
other
but
people a chance.
You have more questions for Representative Bonner?
Well, maybe one, yeah.
Okay, go ahead.
So, actually, you know what? I'm going to wait because it's more discussion.
All right. Okay. All right. A few people that want to be heard on the bill. If you want to step aside, that way they can come up. First person signed up is Vasu Abhiraman. Was I close? You helped me in your first name, I know. It's with the ACLU Council. And you said you're going to both oppose and favor. Is that right?
That's right.
Okay, good. I like that.
Some things we support, some things we don't. Thank you.
Yeah, we can just say cancels out.
That's
Thank
right.
you. Go ahead.
I know it's been a long hearing, right? That's probably the desire.
No, you're good. I'm just making jokes.
Thank you,
Floor is
Chairman
yours.
Strickland, esteemed members of the committee. My name is Vasu Abhiraman, Senior Policy Counsel at the ACLU of Georgia. First, we want to recognize where this bill has come from. Many of the most problematic provisions in this bill have been taken out, and we do recognize the folks who've worked on this bill and sponsor for taking out some of those most problematic provisions, namely those provisions that would seem to force campuses to recognize and support discriminatory groups. That has been taken out, and we do appreciate that. Also, the case that was just mentioned, we filed an amicus in that case in support of the students' rights at Georgia Gwinnett College, and we're also on the record opposing free speech zones on college campuses, given that any public area is an area of free expression. So we speak with investment and authority as a group that has defended free speech for over 100 years on this issue. So the part of this bill about getting rid of free speech zones, affirming that any public areas on campus are areas of free speech, we do agree with those. And the case that was just mentioned was about that, was about cabining a student's speech to a free speech zone when he was trying to speak about his religion in a public area of campus. So that's why we support that portion of the bill, and that's why we spoke out in favor of students' rights in these instances. In fact, we're on the record also supporting Turning Point USA, when they were trying to start a chapter on Arkansas State's campus. And we're told that they couldn't get petition signatures in an area where they should have been able to get it. So again, we support areas of this bill. Some of the things that Senator Parent brought up are the areas where we have concerns. Essentially, what happens in vagueness stays in vagueness. What is a minor disruption? What is a loud or sustained disruption? I want to point out that the law already defines as a misdemeanor engaging in conduct or activity which may reasonably be expected to prevent or disrupt a lawful meeting, gathering, or procession. This is in OCGA 161134. What we would recommend here is to get rid of the stuff about louder, sustained disruptions. No one has the same viewpoint on what that is, and perhaps take a belt and suspenders approach to what's already banned in the code. Again, you can't engage in conduct or expressive activity that can reasonably be expected to prevent or disrupt a lawful meeting, gathering, or procession. If you were to make this bill better, getting rid of that language, but leaving the language in about, and this is from lines 31 to 34, engaging in fighting, violent, or other unlawful behavior, or physically blocking or using threats of violence, have no issues with that language. But again, this louder sustained noise thing, we see many other areas in the law, for example, noise ordinances that define what is prohibited and what is allowed more specifically. Something quantitative is involved. You can hear it from 150 feet, something like that. This right here is a little too vague, and what are our concerns with vague provisions like that? They don't provide adequate notice of what is prohibited, and they can lead to arbitrary enforcement, kind of like the arbitrary enforcement that happens on college campuses with free speech zones and viewpoints that folks on campus and authorities on campus may or may not agree with. So again, there's part of this bill that we do support, but these vague provisions here do trouble us, given that they could have the unintended consequence of chilling free speech. Also want to point out in this bill, and again, there's duplicate language in this bill, so lines 78 and 79. It says, as long as a person's conduct is not unlawful and does not materially and substantially disrupt the functioning of the public institution of higher education. The issue we see here is that materially and substantially disrupts is defined on line 26 through 30, and then it's applied not to interfering with expressive activity, but to the general functioning of the public institution of higher education. I think as a technical drafting matter, that doesn't seem to make sense to so thoroughly define the term. From from 26 through 34, and then to apply it in 78 and 79 to a different context. I'm not sure if that makes sense drafting wise, and I just wanted to point that part out. Finally, again, this bill attempts to, at least the intent seems to be to protect free speech on college campuses, which we do agree with. It contains some great language, like in 66 through 67, where any such restriction shall allow for members of the campus community to spontaneously and contemporaneously assemble. We believe in rights of spontaneous assembly. Also, that any person who wishes to engage, and this is line 77, shall be permitted to do so freely. And I just wanted to point out that another bill advanced through this committee, and in fact was voted out of the Senate, SB 171, that does not affirm the rights of spontaneous assembly or permits given freely to anyone who wishes to engage in a certain activity. We support the First Amendment, and we would just encourage every member of this body to be consistent when it comes to supporting the First Amendment. So this bill is not nearly as much of an issue as that other bill. And if you want to support this bill, I would just ask everyone here to consider what it means to stand up for the First Amendment on college campuses, and then to also advance a bill with onerous permitting provisions, racketeering applied to protesters, things like that. And with that, I'll be happy to take any questions.
You do have a question for Senator Parent?
Thank you, Mr. Chairman. Actually, the issue I was going to bring up was 171 and the bizarre conflicts and
I hear and I understand
vague
the argument,
language.
but let's try to stick to one bill at a time. The bill is still a different subject matter, so to be fair, let's try to stick with this bill.
Well,
You
no,
can
but
make
they're
those
both about
arguments.
protesting and free
I know,
speech,
but-
and it was kind of like, how on earth are we going to reconcile?
But you'll be able to
these two
make
things?
those arguments on the floor of the
But
city.
they have to be
Save it,
looked
so
at.
we'll
Okay.
listen then.
All right. Anyway, my question is.
Thank you.
I just have to say, okay. My question is, as far as what I noticed seemed to be vague language, and actually there is unconstitutionally vague language in 171, in my estimation, given what's been decided in court cases in other states. This legislation, as I understand it, and I do remember it from a couple years ago, when it was more problematic, but I recall that it started out as model legislation from the American Legislative Exchange Council. And so my question is, as it relates to your testimony about vague definitions, which I share a concern about, have we seen court cases about this, since I know it's model legislation, so I would assume it's cropped up in many places all over the country? Or has it changed enough that, you still, mention a concern with the vagueness, and if we want it to stick, it's problematic to have vague definitions as it relates to First Amendment rights?
Right. Well, generally, in terms of vague definitions, I can bring up an 11th Circuit case, Henderson versus McMurray, especially when it talks about loud noises. The noise provisions in that case were upheld in terms of a specific definition about a noise that can be clearly heard inside an adjacent or nearby building by a person using his normal hearing faculties. The terms amplified and heard using normal hearing faculties. These are the kinds of terms that we would associate with something that is precise enough to actually pass muster under the First Amendment when it comes to the term loud.
Well, so what that brings up to me is, shouldn't we, if we do want to advance it, shouldn't we put in language that will pass constitutional muster as opposed to something that your organization might sue and get struck down?
We agree.
Okay. Thank you. We might be interested to see that language.
They won't have anything to do if they can't sue, though. Right.
They got plenty of work right down here at the Capitol, Mr. Chairman.
Be happy to be out of a job.
Any other questions from the committee? Was everything you had, Senator Parent? Is that, I don't want to cut you off, Senator Parent.
Oh, no, I'm fine. Thank you, Mr. Chairman.
Any other questions from the committee? All right, thank you.
Thank you.
We have a few other people signed up to speak. We have Mike Griffin from the Georgia Baptist Association. I can start saying good evening. Soon I'll still say good afternoon. Good afternoon.
I'm telling you, I'm going to have supper night tonight here. My name is Mike Griffin. I'm the Public Affairs Representative with Georgia Baptist Mission Board, and we do support Representative Josh Bonner in House Bill 1. Georgia Baptist represent, as you know, over 1 million citizens, over 3,000 churches. Our Baptist collegiate ministries are represented on approximately 42 of our Georgia college campuses. And so we're in support of this legislation. In relationship to this legislation, we believe that a student's First Amendment rights are not dropped at the door when they enter government schools of higher learning. We think that it's good to have policies in place that add that extra assurance that all students will enjoy the highest free speech protection allowed under the U.S. Constitution. We have nothing to fear from allowing our students the right to peacefully express themselves regarding what they believe and to hear opposing viewpoints. This is one of the beauties of living in a free society and under a constitution such as ours. So we support the Forum Act, and we ask for the committee's favorable vote for it today. Thank you, Mr. Chairman.
All right, thank you, Mr. Griffin. Any questions from the committee? All right, thank you. Next, we have Cole Muzio, the president of Frontline Policy. Good afternoon.
Good afternoon. Thank you, Mr. Super Dapper Chairman. I'll be very brief.
Keep your comments brief, yeah.
I'll be very brief. We support the bill. I think it's really important that we are promoting free speech, particularly at the location where the free exchange of ideas is most critical. We have a silencing of ideas, and I think that is part of what's been discussed today with related to some of the language. It is important that ideas be heard. And shouting down that debate is not as beneficial as the free speech that is being shared at the committee. So we support HB 1, appreciate Representative Bonner, who is my state representative, and I'm super proud of him to be represented by him. We support the bill and ask for its favorable vote today. And I kept my promise to be brief. Thank you.
Hold on, though. You have a question from the committee. Senator Parent?
I do have a question.
Yes.
Thank you, Mr. Chairman. So do you have any other examples of a problematic issue other than the one case that we heard of that's been resolved?
Of free speech issues on college campuses?
Yes.
I think anybody that's been watching news has seen a whole lot of issues with free speech on college campuses, on both sides of this, with either the free speech zones and people being silenced, and also the silencing of speakers that are there to have a free exchange of ideas.
I mean, I have seen a couple things in the press, but not Georgia specific and at all. And the free speech zone thing has been dealt with. I'm just wondering, I haven't really heard.
I
haven't really heard a need for this legislation in Georgia. So I was wondering if you had anything further to offer.
Yeah, I think there's been issues, but I think it's a pervasive issue on college campuses across the board, and I think it's important we get ahead of the case on Georgia. So.
But we haven't. I'm sorry, we don't have examples. I would love to have. If you want to visit me later, like we haven't heard anything. I mean, saying it's pervasive doesn't really get at what I'm asking you. Thank you.
Okay, thank you.
All right, thank you, Mr. Muzio. Next, we have Tony West with Americans for Prosperity. Good afternoon.
Good afternoon, everybody. I'm also here to support this bill. It will provide a constitutionally sound framework for universities regarding their policies on free expression. I want to use my time to address a couple issues my friend from the ACLU brought up. The GGC issue with Chike Uzabunam, it wasn't just a free speech zone issue. It was a free speech code issue as well. He was in the zone, if you will, when he was told to leave. And he was told to leave because a student complained that they were offended by what he said. So a campus officer escorted him off. And that's what precipitated the lawsuit that went all the way to the Supreme Court. So this bill is trying to address those two main things to make sure that students' rights aren't violated just because someone's offended. The court's been very clear about that over the decades, and I think the bill does a good job with that. Specifically in regards to the material and substantial language, the thing with speech codes we find often, it goes from vague. It's very vague, and school administrators don't know where the students' rights begin and where they end. And they end up making a call, and they end up violating a right, and the lawsuits occur. So the fact that material and substantial is so specific is the intent. It's the benefit of it. To take any other suggestion to make it more vague will invite arbitrary enforcement, and that's an issue. So we think the language is correct there. To a previous question about more recent free speech issues on Georgia college campuses, I think the most recent publicized one was from Georgia Tech, where the pro-life group there wanted to bring Alveda King onto campus to speak about, I guess, the pro-life issue in general. and they were not allowed to use their student fees that they all pay into to bring her onto campus. The school was not viewpoint neutral, which is what this bill requires. A lawsuit occurred, and the school was wrong and settled for $50,000. So that is the most recent publicly example in Georgia. I'm happy to take any questions.
All right, thank you, Mr. West. You don't have any questions.
Thank you all.
Last person signed up is Kareem El Hassini. Someone, oh, you are still here. Okay, come on up. C-A-R-R-G-A. Good evening.
Good evening. My testimony said good afternoon, but good evening. And thank you, Chairman Strickland and Judiciary Committee, for the opportunity for public comment. My name is Kareem El Hosseini. I'm the Government Affairs Director with CARE Georgia, here representing thousands of Muslims who live in our state. I'm here today to express our opposition to HB1 as presented. HB1 purports to be a bill protecting free speech, but in fact, if it were to pass, it would only serve to expand and protect hate speech on Georgia campuses, further endangering Muslim, Jewish, and other students from vulnerable communities who are already targeted because of their actual or perceived faith. For instance, in 2019, hate groups targeted Jewish students at least 2 Georgia campuses, UGA and Georgia State, when they drew swastikas on message boards. HB1 also allows for outside agitators to come onto college campuses, provoke students, and encourage chaos. And if school officials take any action to protect their students, this bill allows those agitators to then sue the school at the taxpayer's expense. The author of the bill said that this would reduce lawsuits. I actually think it would increase lawsuits because the bill is a green light for radical hate groups to enter university grounds, all in the name of free speech. And finally, while allowing hate speech to flourish on campus, this bill as written hinders counter-protests by students concerned with the speech, and I think we should be protecting their speech. So we're asking you to consider the real danger students with vulnerable communities will be placed in if HB1 were to pass as written, and ask you to reconsider your support of this bill in its current form. Thank you.
All right, thank you. Any questions from the committee? All right, thank you. Appreciate you being here. That's everyone that signed up to speak on the bill. What's the pleasure of the committee? Motion to pass by Senator Hatchett, second by Senator Kirkpatrick. Is there any discussion? All those in favor of the motion, please raise your hand. We have 5 opposed. We have 3. Motion carries. Representative Bonner, who's carrying the bill in the Senate?
Senator Bruce Thompson.
Senator Thompson. Okay. Thank you. Thank you for everybody's patience waiting around all day. Hope you all had some entertainment today at least. So much. All right. Next bill on the agenda is House Bill 1405. Representative Roberts, you want to come on up and give us just a second to get situated? All right. House Bill 1405, working off a committee substitute LC 471820S. And don't worry, it's too late in the day. I know I'm too tired, but this is your very first bill you ever had, right?
Yes, sir.
And a very exciting topic to take on for your very first bill.
You saved me to the end with zoning law. It's so riveting.
Maybe I was trying to help. Maybe I was trying to help you a little bit.
Oh, I don't know.
You may look back on and say that. I don't know.
Don't punish me, please.
The floor is yours.
Thank you, Mr. Chair. I appreciate y'all staying late to hear this. So basically, this bill just amends Georgia's zoning procedures law to codify the process and procedure for challenging and amending certain land use decisions. Land use decisions are divided into 2 classifications: legislative, which is a rezoning or special land use permit where you go to your local legislative body, your county commission, your city council. And then quasi-judicial, which would be if you needed to put an addition on your house, you went and got a variance. That's a delegated body that sits in a quasi-judicial capacity and applies very specific criteria. So this bill codifies which types of cases fall under each category, And for legislative decisions, the bill codifies that it'll be challenged in Superior Court by de novo review. The judge, and the reason for this is if you've ever been to a zoning hearing, it's impossible to present a full evidentiary hearing in 10 minutes before a county commissioner or a city council. You usually have to prove diminution of property value, appraisal data, sometimes expert, traffic reports, those sorts of things. So up until 2017, for more than probably 40 years, that has always been the law in Georgia. Then there was a Georgia Supreme Court case in 2017, Flowers versus Cumming, a couple of subsequent cases after that that used some overly broad language that now some jurisdictions have been trying to say that it has to go up by certiorari. And the effect of that is that we're having to prepare as if the court is only going to be able to review the record that was below in front of the zoning review board or the county commissioner or the city council. So, you know, we're preparing 5-inch binders to submit to a county commission and a city council. It's expensive for the citizens. It's expensive for the counties and cities because they're having to defend it. So that's why we just want to take it back to what Georgia law has been up until 2017. The second piece of this is the quasi-judicial, and we weren't changing the certiorari. There is another bill, and I think I've fixed our problem, Mr. Chair. But for quasi-judicial, the process for certiorari, I don't know if any of you lawyers have ever done it. It's very technical, and it has a quick time frame on it, and there are non-amendable defects if you screw it up. And so what it requires is for you to go to the county and find somebody to sign a bond and a cost certificate and then serve the individual members of the board, which are not full-time county employees. So we just want the counties and cities to designate someone in their ordinance who will be there during business hours to receive and handle these documents, because citizens could be denied due process through no fault of their own. So that was the original intent of the bill that came through the House. Then I was made aware of a bill you're going to hear on Monday, HB 916, which essentially will do away with the certiorari process altogether. So what I've done in the substitute, after thinking about it last night, is I've changed, if you look at, sorry, I highlighted it. I've changed basically where it referenced the specific certiorari statute. We've just changed it to refer to Title V. So if HB 916 goes through, we'll just follow whatever that process is because it'll be in Title V. And if it doesn't go through, then it still fixes what we need to fix with the code. So I think we've solved it. The other thing that we did is, so the great thing about this bill is that Georgia Realtors, ACCG, GMA, everybody's on board because everybody agrees that this has been expensive litigation cost-wise, and it just needs to be codified. So when I sent them this new amendment to fix the certiorari issue, they asked us to add some additional language on lines, let's see. Basically, it's just putting in the language from a case as far as what de novo review is. I think it's on 205 to 211. So we added that at the request of GMA and their attorneys. So again, there's, to my knowledge, no opposition. Everybody agrees these changes are needed. And I think I've fixed the conflict issue. So I would ask for your favorable consideration today, and I'm available for any questions.
On line 180 of your substitute, such standards may be printed. Should that be a shall? Should we do an amendment on that? Line 180.
I think it's okay. We've changed it, which I thought you did the one at 184, so I made that change there from may to shall. I think we're okay on it. We've looked at it. Because we say on line 184 shall be included and adopted as part of the zoning ordinance.
Well, but I was on line 180, we talk about there being copies made available to the public. And the way it's written here, it seems like it's discretionary whether or not the standards are going to be available to the public.
So all the zoning ordinances are on Muni Code, and you can get a copy at the county. So I think it's covered in that 184.
Any harm in putting shall there?
There
on
isn't.
line
If you
180?
want that friendly amendment,
Okay.
I'm fine with that.
All right. Any questions from the committee? All right. There's one person signed up to speak. You can sit tight if you want.
Okay.
Miss Emily Hurst with Georgia Municipal Association. Good evening.
Good evening.
Kumbaya.
Kumbaya.
Absolutely.
Let's sing it.
Can only go down from here. So
Good afternoon, Chairman, or should I say good evening, good afternoon, committee. Thank you for the opportunity to speak on this bill today. First, I'd like to thank Representative Roberts, who has been fantastically communicative and open to ideas and questions throughout this drafting process. We've worked very closely with Representative Roberts on this bill and have had input on the most recent substitute, as she mentioned. We support this bill because we acknowledge that the state of the law previously was indeed confusing for both applicants for zoning changes and local governments. One of the additions that was made to the new substitute that Representative Roberts mentioned, it just clarifies that we are indeed going back to the pre-diversified holding, pre-flowers status quo, and it just uses that precise language just as a highlight for that. So other than that, I'm happy to take any questions if there are any, but just to say that we support it, and thank you very much for
Thank you. I appreciate it.
all right. Any questions from the committee? All right. Thank you. So no one else signed up to speak on the bill. What's the pleasure of the committee?
Make a motion to pass.
We have a motion to pass by committee substitute from Senator Parent. Is there a second? Second by Senator Hatchett. Do we have any amendments?
Mr. Chairman, I'd like to propose an amendment. Thank you, Mr. Chairman. I'd like to propose an amendment to change the strike may on line 180 and replace it with shall.
All right. Is there a second for that amendment?
Second.
Second for Senator Parent. Any discussion on the amendment? All those in favor, please raise your hand. Amendment carries unanimously. All right. Any other amendments? All right. Now we're back to the underlying motion. Do pass by committee substitute as amended. All those in favor of the motion, please raise your hand. You got it unanimous.
Wow.
And
Thank
who's
you.
going to carry it in the Senate?
I feel like I should say Senator Kennedy, just because people kept, picking.
He's your first choice, all right? Make him feel bad. He needs to get his. He's feeling a little bruised right now. So, yeah.
I know. Senator Parent has agreed to do
Senator
it for me.
Parent.
Thank
Okay.
you so much.
Thank you. I think that's every. Oh, Houston. I didn't know you were here. Houston, do you have a bill on the agenda? Oh, okay. Well, come on up real fast, I guess. If y'all want to wait around, anybody going to stay or? Okay. All right, we have last bill on the agenda, House Bill 1452. We are working off LC 280448. Senator Kennedy asked we hold this bill. I don't know
Well,
what that
I
was
was
about.
going to give up 3 hours ago, but realized it's for victims of domestic violence. It was important and worth the wait. So.
Quit trying to make it where I can't make jokes. Okay, the floor is yours.
This bill is 2 words, very simple. It just changes. Last year we passed House Bill 231, which gave victims of dating violence the opportunity to seek a temporary protective order against their abuser. Last year we worked where if they were currently dating or had been dating within the last 6 months, and I think we tightly defined dating relationship to ensure that we crafted language that it will address the concerns that were brought forward and feel really good about legislation we passed this year. I actually had a UGA student who reached out to me. She had an issue where she had been sexually assaulted, and because it had been 8 months since they had been in a dating relationship, the judge had to deny the TPO, and so what we've done here is extend that to 12 months and bill that passed unanimously in the House. Have Rebecca Grice, who worked closely with us on this last year, solicitor in Macon, and we'd both be happy to answer any questions if there are any.
Ms. Grice, do you want to share anything as well?
Just wanted to echo that we are supporting this bill. This is very important. I think last year we tried to tailor it as narrowly as possible to address any issues or concerns, but realizing, a year into it or 6 months into it, that there were a lot of cases that were falling through the cracks because the time frame was just too tight. And just in comparison, even the state of Alabama has 12 months of a look back, and we have 6.
Ooh, bad when Alabama's doing better.
Well, we decided in the House that we should always be better than Alabama, just like we were on January 10th.
That's
Yes,
true.
absolutely.
That's a good move. I have a question from Senator Cowsert.
Thank you. Am I correct that this is not creating a new crime? It only applies to those temporary restraining orders?
That is correct. That is correct.
And would you just refresh us, what was that definition of a dating relationship? I need some assurance it's not like just, having one blind date and then being subject to a restraining order. I can't remember how we defined it.
Tightly. Hold on.
Pull
But
that.
we had a lot of discussion, if you'll recall, last year to tailor it as narrowly as possible. And I can't quote it off the top of my head. I sincerely apologize.
And Ben or Michael, either one of y'all have that up, you can read. for
There
the
is no
committee.
change to the definition we did last year. It's
So
just an extension of time.
I can read it for you, Senator. A dating relationship means a committed romantic relationship characterized as a level of intimacy that is not associated with mere friendship or between persons in ordinary business, social, or educational contexts, provided, however, that such terms shall not require sexual involvement.
Okay, thank you.
And that was from the legislation we passed last year.
All right. Any other questions from the committee? There's no one else signed up to speak. What's the pleasure of the committee?
Make a motion to pass.
We have a motion to pass from Senator Hatchett. Is there a second? Second from Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. All right, carries unanimously. And who's going to carry this one?
Do we have any volunteers?
Senator Kennedy?
Senator
We were
Kennedy.
asking.
Maybe. He's can.
Today's gone, I can't tell you how much that
But let's get your mic on. Everybody can hear at home.
You gotta support.
I can't tell you how much that means to me, to the both of y'all. Thank you. I'll be glad to carry it.
Thank you very much. Thank y'all.
All right, thank you. Appreciate you. All right, thank
Hope
you,
to be
members.
back soon.
Oh, yeah.
Just
Maybe.
kidding. Just kidding.
Hey, thank everybody for their work. As you saw, we kind of front-loaded this one to hopefully help a little bit to get ahead on bills for next week and have more time for next week for revisiting stuff like the one bill today we'll revisit. So with that, we're adjourned.